So on previous occasion, whatever discussion we had, 2 points emerged from that. One was regarding periodization, which refers to that modernity, post-modernity is after modernity. And another point was that it is not periodization, rather it is categorization, in which the categorization submitted by or propounded by modernity that was replaced by its binary or by its opposite. So in that way, we have observed that while equality, rationality, and universality, that were the categories which were propounded by modernity, they were sought to be replaced by another category which happens to be opposite, or we call it binary. And they are: against equality, there is difference; against rationality, there is emotion; and against universality, there is particularity. So, first thing is that whenever we use the term modernity, post-modernity, it may be understood with reference to these two: after modernity and various kind of categorization. Therefore, because of its uncertainty in its meaning, many of the thinkers have used the word that post-modernity is a notorious concept. Be it notorious or not, the thing is that what it wants to communicate, it simply wishes to communicate that modernity, the promises which were made by it, could not be fulfilled, could not be attained, and therefore there is a need to go for an alternative. So if we see the jurisprudence which we have studied earlier, they will be talking about the nature of law, what law is. Bentham will say that it is the sign or what you call uh, assemblage of signs that is declarative in nature, which expresses the will and volition of the sovereign, and that will and volition is with respect to the people who are the subject of that sovereign regarding their behavior. Okay, they do not make distinction that the expression of will of the sovereign for the community happens to be different for different members of the community. They will be Bentham will speak one thing to all, be it male human being or female, be it a child or girl child or a boy child, male child, irrespective of that. Similarly, when John Austin is using the term of law, that it is sovereign, gives command and sanction is the essential element in case of its violation, then he is not talking about the categories. He is simply saying that the origin or the source of law lies in the sovereign. And this law is in the form of command, which is to be obeyed generally, habitually, by the political inferior. And in case of its violation, sanction will be there, punishment will be there. So he is again not talking about any particular category or any particular class of person to whom this will be applicable. If we see the Kelsonite doctrine of Brandar, he is trying to give a picture of theory of law applicable in all the situations, irrespective of its category. And he will say that it is study of norms, and these norms are in fact study of arts, different from that of moral arts. It is study of legal arts, and therefore, again here he is not talking about the thing which is applicable to a particular person or particular place. They are talking about universality. Universally, the law is the study of norms, and there is one science of law that from the grundnerve all the norms originate. If you see HLA Hart, he is again a neo-analytical and positivist. He will say that law is system of rules, making a difference between primary rules and secondary rules. But at the same time, he is saying that it is combination of the two, primary rule and secondary rule. Again, here you will not find that he is talking about the applicability of law to a particular section of society. No, he is talking about the nature of law. Law is the system of rules, and in which primary rule and secondary rule, they unify, they combine, and they create the system of rules. When we see it from functional point of view, then they say that law has a purpose, law has a role to play in the society. And what is that? It has to protect the interest. Again, they will not say that this interest will be of which category. They will simply say that there are certain postulates, there are certain assumptions, and those assumptions may be realized with the help of law. So for them, law is an instrument by which a happier society can be made, in which every person shall be able to assume that there shall not be any intentional aggression. But when we come to realism, realists, they try to bring an element of difference. Realists, they bring an element of difference, and they say that what appears is not the reality, and what is the reality that does not appear. For the first time, the realists, they are trying to indicate that nature of law may be understood by understanding the background of the judges or the persons who are on law jobs. That is their first approach, that law is not the same which is written in the law books, rather as it is understood by the judge. In that way, we can say that realism, it brought a new kind of thing, and particularly the contribution of Jerome Frank, that he brought the concept of skepticism in the area of rule as well as in the area of fact. I am not going to that. My point is simply is to indicate that while analytical positivist and sociological school of jurisprudence, historical school of jurisprudence, they did not try to understand the the effect of law on a particular category. Rather, they were interested in understanding the nature of law, not the nature of the person who was behind it, either the interpreter or the beneficiary of that. Because there was no categorization in this form. What was reasoning, that was understood to be reasoning of all, and everyone was to accept, and it was believed that it will bring happiness in the society. When I do not know whether you have gone through the concept of feminism or not, but have you कुछ फेमिनिज्म के बारे में पढ़ा है आप लोगों ने अभी तक कि नहीं? स्त्रीवाद, विधिक स्त्रीवाद.
We had a brief knowledge about the word feminism, but in
No,
English,
even if you have some idea about feminism, uh, I am not saying that you must have gone through it in detail. But feminism is tries to give a gynocentric approach to understand law. Why women are still under subordination, subjugation, and subject of exploitation and oppression. So they take only one category out of that, not the entire Homo sapiens. Uh, they take out one on the basis of their sex, that they are different, they are distinct, and therefore law for them should be different. So when you go through the classical approach to feminism, they will be talking about equality between sexes. Whatever right is available to man, that right should also be made available to woman on the principle of equality. both man and woman, they have got autonomy over their body and mind, and therefore there should be law equally available to both of them, particularly conferring rights and duties. Uh, so far as socialist feminism is concerned, they say that uh, equality is not possible between man and woman unless and until there is woman empowerment, and that can be done by economic empowerment. If she is also permitted to work, then she will be empowered. And they suggest, the socialist feminism suggests that man, while making law and the system, social system, has made the system in such a way that it favor that it favors the man but not the woman. How? What is the basis? What is the ground? They say that man is involved in production of anything, maybe in factory, maybe of food grains, maybe of garment, maybe of machines and heavy machines. But woman is involved in reproduction. Reproduction has not been given the same value which the production has been given. And who has given the value to it? It is the man who has given the, or male who has given. So law is predominantly masculine, they suggest. So one category of woman was sought to be taken out of that. That was the second attempt. After realist, it is the feminism who tried to make this attempt. Now, after that, there was critical legal movement or critical legal studies movement in in last 2 decades of 20th century, and it believes that the reasoning given by the law traditional law thinkers or classical law thinkers, that law has independent reasoning, that does not hold good. In fact, the reasoning of law is the reasoning of the polity. Law has no independent ideology apart from that of political ideology. So there is no difference between political ideology and law, and it is only a myth that law has got independent um, autonomous ideology. No, it is not like that. Law depends upon the ideology of polity, and therefore they say that law is not fair in their commitment. The classical school of criminology, and particularly based on modernity, it says that law should be based on the principle in which certain elements like subjectivity should be should not be there. Law should be objective, and we say that man's behavior is the result of man's behavior is the result of the will and volition. But at times we also find that man's behavior is not because of his will and volition. If we take the example of criminal law, then we say that the wrongful act was done, that wrongful act was done intentionally, voluntarily, willfully, and then he will be held liable. But at the same time, the same law admits that there are certain situations where the act done by man may not be regarded as his voluntary act, maybe accident or maybe other situation. So we cannot say that always the act done by man happens to be based on his conduct, willful conduct. It is not like that. So what they are suggesting is that there are predetermined conditions which make the person liable. But at the same time, we also use the word which are not predetermined, predefined, but depends upon the fact and circumstances. For example, we use the term reasonable man. So, reasonable man, who is reasonable man? Just logically, we can say that man of ordinary prudence who would have behaved in a particular manner in given situation. That person happens to be reasonable man. While the feminist will say that why not reasonable woman? Can't woman be a reasonable human being? Their logic is from gynocentric approach. But the critical legal studies, it will suggest that on the one hand we are talking about objectivity in law, but at the same time subjectivity also comes. While law is the result of the objective principle, but sometimes we say that law is to be governed by certain systems which are not predetermined. Uh, when the question arose that whether a person could take the benefit of certain relationships which were not exactly contract, then a new proposition comes that no one can be permitted to become rich at the cost of other. That is called quasi contract. You must be aware that there was a time when when it was not treated as a contract where a person took the undue advantage of the situation. For example, the finder of goods, a person who has found the property of another person, he was under no legal obligation. But law created this relationship as if it resembled the contractual element, as it resembled contractual element in it. Quasi contract emerged in the case of Moses versus McFarlane by Lord Mansfield. So, point here is that while modernity was trying to push the development of law on the principle of reason and rationality, this post-modernity is saying that this reason and modernity has not done anything substantial, rather it made the life deplorable, and therefore new dimension should be given to it. Now, what new dimension it has given? As we have already discussed in the concept of postmodernity. Just a minute. हेलो हाँ सर नमस्कार हाँ सर अभी एक क्लास ले रहा था changing the scenario. The first thing is that it has shifted the study of law from that of analysis of nature and system of law to that of the nature and system of understanding the legal provision by persons who are involved in it. So we should not go to understand what is the legal structure and what is the provisions of law. Rather, how that provision is received by the person who is supposed to deal with or confront with that provision. And therefore, there is death of the subject. Now, the subject of law is not a class, community. Rather, the subjects are many. Now, law can be with reference to women, with reference to girl child, with reference to boys, with reference to transgender. Many categorizations have been done. Earlier, it was not like that. Law, once it was promulgated or made by the sovereign or by the body competent to make it, it was applicable to all. But now it is said that justice is not being done to all if we go by this principle that law is applicable to all without considering the particular condition of that individual. So there should be categorization or individualization of law. You can say that it has been fragmentation of law, depending upon the. Then the second thing is that emphasis is not in understanding the provisions of law or analysis of words or the genesis of the word. Rather, how that word is received by a judge, by law administering person, and the consumer of that law, legal provision. So it may appear that right has been conferred, but in fact there is no right. If I substantiate this statement, that when we said that there is a fundamental right to have clean water, on many occasions the Supreme Court of India has said like that. So right to clean water, right to have clean water, from a modernist, from a point of view of a modern concept or modernity, we can say that it is a right in which every person is entitled to have fresh water, clean water. It should not be contaminated one. But when we construct it in the postmodern scenario, we find that right has been declared, but its effect has been that on the consumer of this right, that has suffered. Means water will now come in bottles, in cans. It has become a what you call marketable commodity. Earlier, water was not sold. Now we are selling it. Now it has become a commodity for sale and purchase, and we are having the right to clean water. Moreover, right to provide clean water happens to be the duty of the state to provide. But by such method, state has withdrawn itself. So if we see it from the postmodern angle, we can say that right has been given in a form, but in fact, this form is not a right. It is a burden. It is a what you call cumbersome. Cumbersome in the sense that you have to pay for it, and after paying only you can get the clean water. Otherwise, not. Similarly, there may be various rights like right to education. Right to education means the state has withdrawn itself from providing the education. It will be right of the person to receive education, and if any educational institution, private in nature, interferes in that, that body may be taken to task. But so far as the role of the state is concerned, against whom the right is available, that has gone. So the first thing is that there is death of the subject. Now there are many subjects. It is, or you can say, there is indeterminacy in subject. I hope you are getting my point. Hello, hello.
Yes, sir.
When we use the term death of subject, it means indeterminacy of subject. Who who will be the person using this process, that we do not know. Earlier, we were knowing that this particular law is applicable to all the persons. Now we do not know to whom it will apply. So indeterminacy of subject. Number two, the effect of this indeterminacy is fragmentation. Fragmentation in a sense that with the advancement of knowledge by postmodernity, we develop specialized knowledge in various areas. Earlier, if I uh, take simple example from our routine experience, that earlier there was one physician called family physician. He used to treat all kind of disease and infirmities in the body. He was a physician, he was surgeon also to some extent, he was pediatrician also, he was ENT surgeon also, so on and so forth. But now we are having specialized knowledge. So man body is fragmented. Number one, if we take the example of citizenship, now you will find that there are various categories of citizenship. PIO, person of Indian origin, if I take the example of India, then overseas citizen of India, OCI. Then you are talking about those who are of Indian origin, having citizenship of another country, but because they are having their roots in India, therefore they should also be given certain rights. So in that way, we can say that even the concept of citizenship, which was in the traditional sense, that does not exist anymore. We are talking about other categorization. Now, if we proceed further regarding the forum of enforcement of laws, then you can find, or you can assess very well, that traditionally we were having court system. There was a court which was to administer justice according to law. Now there is fragmentation, that gradually the concept of tribunal comes. Then tribunal was having specialized knowledge in that particular area, maybe income tax tribunal, maybe labor law tribunal, maybe administrative tribunal, so on and so forth. So various categories of tribunals were constituted, and the reasons were twofold. Court is not supposed to have what you call specialized knowledge, and there was huge expense as well as time-taking process. Therefore, it was thought that new system should be introduced. So court was divided into other category, that is tribunal. Now we are having various kinds of forums, maybe consumer forum or commission also. So there is fragmentation of the judicial system as well. Now, another important aspect in this connection is that not only the legal provisions and the forums are being bifurcated and fragmented, even the post-modernity has an effect on the traditional concept of our statehood. If you see the impact of post-modernity on the undivided and erstwhile USSR, earlier USSR was one, but due to the demand that our conditions are different, our cultures are different, and therefore there should be separate state. If you go by the State Reorganization Act in India, enacted in year 1956, it will indicate that the state was formed on principally on the basis of culture and language. So the state having common language, majority are having the common language, and but administrative convenience was not there. It was quite difficult for the administration to administer that state because of its huge size, maybe because of the person who are having different language and culture, but because of the fact that predominant language and the culture is of a particular community, therefore it was brought in one state. When in Gujarat was separated from Bombay, earlier Gujarat was also part of Bombay, At that point of time, the region which was given, that Gujarati, they have different and distinct culture and language, and therefore it should be separated. But nowadays, the demand is not on this basis that the language is separate or the culture is separate, and therefore now we are saying that it is particular community which is in minority or majority, on the basis of which there should be separation. For example, Jharkhand, that was divided or bifurcated on the basis that there was a majority of tribal community. Their culture was distinct and different from that of North Bihar, and therefore there should be separation. Similarly, Uttarakhand, division of Uttarakhand, that was on that very basis. So, point is that the state is divided on these, and Telangana, case of Telangana, that Telangana culture is different from that of Andhra culture. So, in that way, we can say that this postmodernism is responsible for fragmentation of state even. And not only this, postmodernity gives rise to various meaning to a same word. It indicates that the word has no sacrosanct and fixed meaning. Rather, the word receives its meaning, a different meaning at different point of time in different context. So it is said that when a word, that is signifier, proceeds, moves, moves with the passage of time, then that signifier assumes altogether different signified or meaning. So signifier and signified both are constant and transcendental sacrosanct. That very belief, that does not hold good. Rather, meaning is variable. The meaning changes in time-space dimension. Same word may be used at two different places, and two different people, they may understand it differently. Now, this point can be substantiated by taking help of, again, realism, that when an accused is looking for release on bail, he is not interested in seeking the rationality and reason for getting bail or not. He is simply interested in the fact whether he is going to get bail or not. What logic has been taken, what precedent was there, what the law is there, he is not concerned with. He takes the law only with reference to a result which is applicable on him. Similarly, postmodernism or postmodernity in law, that says that your law which has been made, that might have been good at one point of time, but it is no more doing justice to us. Uh, what happened that uh, the seats in the parliamentary system and the legislative bodies were reserved on the basis of category: scheduled caste, scheduled tribe, OBC, so on and so forth. After that, the seats are reserved for, though there is no official allocation so far as parliament and state assemblies are concerned. There is no constitutional right or constitutional provision for that. But now seats are being reserved for women also. It means a new kind of categorization that is coming up. That seats for women in Lok Sabha and Lok Sabha, Raj Sabha, and Vidhan Sabha, all these are coming up. Words are changing its meaning. Legal systems are being modified. In addition to the legal system in the form of forum, commission, tribunal, and regular court, we are witnessing one more thing, that is called arbitration and conciliation. That instead of resorting to a particular forum like tribunal or court, regular court, parties prefer to go for arbitration and mediation. Why? For them, it is good to get the resolution as early as possible instead of fighting the case on the principle of law, and everyone will try to define and understand the law in his own way. Therefore, in postmodernity, while it gives autonomy to each and everyone, it gives a freedom for each and everyone to understand a situation in his own way. You can say that in modernity, freedom is there, but freedom is under control, kept under control on the principle of reasonable restriction. But so far as modernity is concerned, in the name of rationality, in the name of equality, in the name of universality, no such restriction can be put on the person. He is free to, he is free in his own way. One should, how one should behave, how one should put on a particular dress, it is up to him. And another significant point in postmodernity is, hello, हाँ रहता, हाँ 1:30 Another significant point in postmodernity is that this very concept that people are selling only the tangible properties, that has gone under change. No, now you will find that intangible properties are also being sold and purchased. For example, your intellectual property rights. Earlier, it was neither protected nor it was subject matter of sale and purchase. Patent right, trademark, all these things, just in order to maintain the monopoly. And when the intangible things are being sold, or signs, SIGNS, when signs are being sold, then your traditional law relating to sale and purchase, that may not hold good, and therefore law is to be viewed afresh. In postmodern era, when we are talking about the risk in the society, as I told you that in my earlier lecture, that Ulrich Beck, he said that modernity brings risk, and this risk is more in postmodern conditions. So, in postmodern conditions, the risk is sold and purchased. Man may feel better if he has purchased that risk by paying some premium. Vehicles are on the road, there is a likelihood that it may be damaged or destroyed because of some accident. So once a person has, or the person may injure other person using the road, so one will be feeling safe if he purchases something which is not in the form of commodity, rather in the form of risk only. There is an apprehension that this may happen. So the thing does not exist in reality, but that is subject matter of this the sale and purchase. When we were taking life insurance policy, at least there was a life, and that, with a view to save that life, policies were taken. But now, when we are entering in the domain where there is a risk to your property, risk to your life in other ways, that risk is being purchased, and risk is maybe of various kind. Risk maybe to the body muscles, risk maybe to eyes, color and complexion of eyes, so on and so forth. So earlier, entire life was insured. Now we are insuring it in fragments, and that too only on the basis of risk, that the society is become risky. And this risk is man-made risk. It is not the natural risk. Or you cannot say that this catastrophe is due to some upheaval in the geological condition of the flow. No, it is not. Sometimes we have observed that catastrophe occurred because of human behavior. Maybe Chernobyl blast or several other blasts like this. Yeah. Then the point which we were discussing, that the words, they are not having fixed and constant meaning. The words are subject to change, and the concept which we are having in modernity, that is also subject to change in the postmodern era. The very belief that the power which is flowing from top to bottom. There was a famous saying, jaisa raja vaisi praja, means it is the king, it is the ruler. His personality, his character will decide the personality and character of its people. But no, this does not hold good anymore. Rather, it is the people who have to decide what kind of ruler he wants, what kind of person he wants who could rule. Now it is for, if the society wants, take simple example that it is the time of election everywhere in this particular state. If the society wants that the government or the ruler of this particular state should be such a person who satisfied our religious faith and belief, then he may choose such party. If a person feels that we want to satisfy our worldly demands or worldly requirements in the form of um, employment, in the form of education, in the form of health, so on and so forth, then the person may go for that. Point here is that the very notion that the power flows from top to bottom, just in a fashion in which water falls from top to bottom, from higher altitude to lower altitude, that was the concept in modernity. But in postmodernity, it is just the reverse. Process is reverse. From the power is derived by the leader, not assuming himself to be a powerful man, but power is conferred by the people at the lower level. You can say that it is a democratic principle. As I told you earlier, that modernity is one of the important features of modernity. Democracy is one of the important features of modernity. This democracy further crystallizes in postmodern era. So power in democracy earlier, the power was flowing from top to bottom, but in a postmodern society, democracy moves just in reverse direction, from bottom, from the people to that of the man at the helm of the affair. Just a minute, please wait for a second. I am joining you. Sorry, there was some disturbance. Okay, so this happens. The predominant function of law in a society other than postmodern society happens to be oppressive and repressive. If you go to that society which was not postmodern, then you will find that controlling the behavior of the man by imposing oppressive punishment, that was the significance of law, that was the utility and utilization of law. But as and when the society moves towards postmodernity, the element of restitution, reformation, that intervenes, that comes into. तो जब समाज आपका उत्तर आधुनिकतावाद की तरफ बढ़ता है, या जब मॉडर्निटी का उत्कर्ष आता है, तो ऐसी ऐसी स्थिति में जो दमनात्मक और दंडात्मक स्वरूप विधि का होता है वह मध्यम पड़ जाता है, हल्का पड़ जाता है, और restitutive and compensatory kind of jurisprudence that emerges. Now, this point may be understood with the help of the cases, particularly decided by the Supreme Court of India, that there was a time when the court, while interpreting Article 21 of the Constitution, said that we are concerned only with the life which is animal existence. We are not supposed to deal with the dignified life and quality life. But subsequently, it not only recognized the quality life, not only the dignified life, but it also came to decide that if there is violation of fundamental right, then compensation can be given to the person whose fundamental right has been violated. So, constitutional tort as a new category started. I told you that postmodernity is a kind of new categorization. So, constitutional tort, which was not known earlier in the first 25 years or 30 years of the history of Supreme Court of India, that gradually came on surface that Supreme Court is not only to enforce the right, but in case it has been violated, then compensation or compensatory jurisprudence should also be developed. So the formalities, the form should be done away with. Come to the substance. So the modernity that was concentrating on its form, but postmodernity goes for the substance, not the form. There may be butter kept in an earthen pot, it will remain butter. But if it is not, even if it is kept in a gold box, that will not convert the quality of that. So if it is uh, palm oil or what you call other oil, if it is kept in the gold jacket or gold container, it will not convert its nature. It will remain the same. And butter, that is good thing that the content is good. Wherever it is kept, it may be kept even in earthen pot, but that will remain a good article. The point is that form should not be the restriction and obstruction. Therefore, you will witness whenever you will analyze any case law that there is an attack on formalism, no different form. ये नहीं है कि साहब हम व्हाट यू कॉल लड़की है या महिला है तो हमें इस तरह के कपड़े पहनने हैं या उस तरह के कपड़े पहनने नहीं. देर इज नो फॉर्म, देर इज नो फॉर्म. There may be confusion that the person moving on the road is a boy or girl. No, forget about that. Similarly, even in the legal system also, wherever certain formalities were there, those formalities are being diluted gradually. Earlier, if a person was having a case for violation of fundamental right, he was to file a writ petition for violation. Now that was modified just by sending a letter. If the matter is of public importance, public interest litigation may be filed. Earlier, it was not like that. Though there is some dilution in this method also. But the point is that formalism has been attacked and it has come to a rupture. There is a fissure. There is what you call, there is a pressure on formalism. Content is more important. So that is one aspect. Another aspect which is to be looked upon is that the law should not talk about only the production mechanism, that what should be the factory rule, what should be the trade union rule, what should be the rule relating to social security. There should also be provision for addressing the issues, problems for consumers as well. What John Baudrillard has suggested that in traditional society and in modern society, the emphasis was on production. Particularly, he is referring to Karl Marx, that Karl Marx has given undue advantage to production, but he remains silent on the consumer aspect. So the producer and the consumer interest of both must be maintained through the system of law. आप एक तरफ होकर के केवल और केवल जो उत्पादक हैं उनके नियम उनके अधिकारों को संरक्षित करेंगे और जो उपभोक्ता है उनके अधिकारों का संरक्षण नहीं होगा, तो ऐसी स्थिति में समाज में एक विघटन की स्थिति उत्पन्न हो सकती है. दैट इज नाउ द लास्ट पॉइंट व्हिच आई वुड लाइक टू शेयर विद यू इन दिस रिगार्ड इज दैट व्हेन मैन रीचेस टू पोस्ट मॉडर्न स्टेज, here failure is not accepted. In a post-modern society, failure is not acceptable. What is accepted is only success and success and success alone, nothing else. So you may come across a situation where no one would like to have less than 100 marks out of 100 marks. Whether that is genuine or not, he will not. Reason is that the element of reason is being replaced by emotion. I should be successful. I should get 100 marks out of 100 marks. It is the reason that which makes distinction that why should I get 100 marks and why should not. That reason is not being cared. So emotion becomes a very important component. हेलो, हाँ नमस्कार, हाँ बताएं. हम्म. अच्छा अच्छा, ठीक है. तो हम जो है आपको ये जो रजिस्टर है ये हम आपको करीब 1:45 के आसपास दे देंगे और आप जो है फिर शाम को हमको इसको दे दीजिएगा, क्योंकि नहीं तो ठीक है आप उसको भेज दीजिएगा. नहीं लेकिन हम खाली नहीं रहेंगे, हम बिजी रहेंगे. तो अच्छा ठीक है, आप भेज दीजिए 3:30 3:45 के बीच में. ठीक है, ओके. So yeah, so emotion is gradually coming up in a big way. Reason is not important anymore. Important thing is the satisfaction of need, satisfaction of want, and expansion of those elements which are predominantly based on emotion. And the last point is which I would like to share with you is that now the time for universality in human behavior that has gone, that has come to an end. Now we are talking about individuality. I am like this only. And there was a time when people used to say that my behavior should be commensurate with or compatible with other as well. But in postmodern society, there is uh, there is individuality. I am not governed by the uh, wishes and desire of other person. I am the master, sole master of my behavior and conduct. I will behave as I wish. तो ये जो कभी कभी कोई पता नहीं हिंदी है या पंजाबी है, मेरी मर्जी का कोई एक सॉन्ग है, ये क्या है? ये बेसिकली आपका कल्चरल एस्पेक्ट है पोस्ट मॉडर्निटी का. मैं ये करूं वो करूं मेरी मर्जी. व्हाट डज इट शो? इट शोज दैट मैन वांट्स maximum liberty and freedom and that should not be controlled by any external agency. That is therefore it is being said that postmodernity is shallow in its content and nature. It is just like a froth, a foam, which has come on the surface, but it will vanish. It will vanish like a bubble. And ultimately, modernity, that is the reason, rationality, equality, that will prevail in the society, and society can move in that direction only. And and therefore, the principle on which our laws were based earlier, prior to advent of postmodernity, those laws will be successful, but not this one. Man wants that he should be governed, treated differently, but it is only short-lived. Now, to conclude this entire lecture, so far as postmodernity is concerned, we can conclude that postmodernity is, for the purpose for our purpose, is not after modernity. Rather, it is categorization. And in this categorization, the subjects are indeterminate. Our subjects have become indeterminate. Some will say that there is death of subjects. Indeterminacy means how many subjects can be there, that cannot be determined beforehand. One thing, and there will be a process of fragmentation, and the variation and variables will be many. So each and every person, each and every culture, that will be distinct in its approach and understanding. Law, same provision will be understood by one man in one way, and other will understand it in his own way. So we may think that reservation is bad because it is undermining the merit. It is not taking into consideration the merit of the student or the job seeker. But those who are for this reservation, they will say that, look here, that is the only way by which the unequals may be brought at par with that of the equality. So at times there is inner contradiction also. The person who is saying that there is no equality, he will say that to bring at par with those who are in a better position, uh, some reservation should be there. So person may say that reservation is bad, reservation is good, depending upon his understanding. Further, in the category those who are getting reservation, they may say that no, look here, this reservation has no significance, no importance, because this particular reservation is being consumed by those who have become slightly better than us. For example, there is what an allegation type of thing, or contention. Better not to use allegation. Contention is that while giving reservation to OBCs to the extent of 27%, the benefit has percolated only to those who are Yadav and Patels, not to others. There are many other castes which fall in that category. They are saying that this reservation has no meaning unless my category, maybe Nishad, maybe mm, uh, Rajbhar, or like that, they are given reservation in various jobs, etc. So that is their perception. While the other, the state contention may be that, look here, you people are fighting on this issue of reservation. So why not? The very issue of reservation should be diluted, that there will be no educational institution, there will be no place of employment, or public sector seeking employment there. So in there may be, they may have their own perception, and that's why it is said that the duration of a postmodern understanding is not longer. It is a shallow concept. For a time being, it may please, it may be useful for sensual pleasure, but in long run, it may prove to be fatal for entire humanity. This is all about so far as postmodernity is concerned. If you have any doubt, if any query, you may raise it. I may not be able to solve, but certainly I will give a thought to that problem in case you are having any. So no query, nothing of that sort. You don't have any query on this topic, Mr. Chauhan? You don't have any problem. You don't have any query on the entire thing. No,
Hello.
suppose hello. Suppose I put a question to you that you have to write your thesis in a particular area. How can you use this concept in your thesis? Is anyone working on is anyone working on in the area of environmental law?
So I'm not actually working in the field of environmental law, but
प्रशांत ठीक है नेक्स्ट अरविंद कुमार फादर का नाम बताओ बेटा अपने अरविंद कुमार हो ना Smriti Roy, you wanted to say something? अच्छा अमित कुमार No. Next.
So actually, we are still doing the coursework thing, so haven't really decided about our topics yet.
You have not decided, even you have not decided your area of work.
No, sir. Area of work is decided, but topic as such is not finalized as of
In
now.
which area you are working, by the way?
So I am thinking in cyber law.
Cyber law. So,
Yes.
if you are talking about cyber law, what does it mean? What is cyber?
Cyber, as of now, has a very wide concept. Like it's still widening because of the new developments that are taking place. So I haven't really decided upon what exactly in cyber law, but I think something related to IT Act or maybe a few loopholes that are there. Like there are still a lot of issues that have
No,
not been
the,
dealt up
the,
with
the,
in India.
the concept of boundary that has been diluted. The boundary has become more porous. You are using your computer sitting in Kanpur. The server is placed somewhere in Israel, and the service provider is somewhere in Singapore.
Yes, sir.
So, how to prosecute someone if any offense has been committed or any if any liability has arisen?
Yes, sir. So yeah, the jurisdiction problem arises, and there are a lot of other issues that need to be dealt with, and which have not been dealt with as of now.
So earlier you were having only the seller and the buyer. Now you are having the concept of service provider. A third person has come in.
sir, also I want to add up something in this. Sir, in pointing out the jurisdiction, we are mainly concerned with the in pointing out the jurisdiction. There is a new concept which has been developed that we are discussing on the point of origin.
Hmm.
The point of origin means that how the uh, particular data has evolved and in which jurisdiction it is there. And in this area, the international perspective also comes into play because if the crime is committed, for example, in France, then it would be said that the jurisdiction relating to France and India कि हाउ इज देयर एनी एक्स्ट्राडिशन ट्रीटी रिगार्डिंग दैट सो यहाँ पे सर एक पॉइंट ऑफ ओरिजिन का कंसेप्ट डेवलप हुआ है जिसमें कि आप ये देखते हैं कि क्राइम जहाँ कमिट हो रहा है वहाँ से हमारा रिलेशन क्या है और दूसरी बात यह है कि द क्राइम के जो जिस बेसिस पे उसको पेनलाइज किया जाएगा, उसमें उस कंट्री के लॉ या उस पॉइंट ऑफ ओरिजिन वाली प्लेस के जो लॉज हैं वो भी
where the act was done, there it
यस
is not an offense. What will happen then?
यस सर
Suppose the point of origin happens to be India and that particular behavior has not been criminalized in India. What will happen then?
सर उसमें जो प्रैक्टिकल सिचुएशन में इसमें लॉ ऐसे डील करता है कि व्हेन दैट पर्सन इज travels outside India, then an Interpol notice, or depending upon the severity of the crime which he has committed, so an Interpol notice or search warrant has been
When
So,
we ex-
so इस जगह पे I think treaty also plays a role. Like if there is a treaty that already exists between the
so,
two
so,
nations.
usually the concept of extradition is applicable when at both the ends the act behavior has been regarded as an offense. There should be a concept of double criminality. It should be crime in the place of origin as
Both.
well as the other place. If it is not crime in our country, then we cannot extradite such person.
yes
Is
sir
it so or not?
yes sir, extradition is not possible, but when that person moves out of the country in the form of any um,
Mr. Chauhan, my topic was postmodernity, where when the society was modern or pre-modern, at that point of time, for committing an offense, there must have been synchronization between the offender and the victim. Now, the offender and victim they are in a state of non-synchronized state, and they may commit the offense. Such offender, though not synchronized with this victim, but he is capable of committing the offense. So, how to deal with such situation? The person has not seen anyone, maybe through social media, maybe through internet, whatever it be. So, cyber space, where the things are traveling in the space, and by that method, person is committing the offense. There is no what you call real contact between the victim and the offender. Nevertheless, offense is committed. Earlier, it was not imaginable. Or there can be hacking of your computer, and because of that, money was taken out of your account, or it was demanded from someone else. So in that way, without having the synchronized method, person is committing the offense. There is no real movement of real property. It is only the digit which is being transferred from one place to other. So how can you apply the law relating to theft 378? That point is that you may, whatever be your topic, you may use the concept of postmodernity, and you may take that part which suits for your purpose. Otherwise, it's okay. You are working on the personal laws. So personal law means uh, there is there is fragmentation of the institution itself. The husband and wife they are having rights against each other. Earlier, the concept was that after marriage, the rights and liabilities of both merged with each other. It was the responsibility of the husband to take care of. It was the responsibility of the woman to take care of her husband. So, in this way, the concept was developing. Whether they were having this actually or not, that is different issue. But law was of that nature. But right now we are saying that no, the husband and wife they are different, distinct. They have their autonomy. The wife may decide in her own way, husband may decide in his own way. So in that way, it is an attack on institutions as well. Postmodernity attacks on the institutions as well. So I think that this is all about postmodernity, and there is no point of having any discussion. You please go through it, and in case there is any confusion, doubt, we may meet again. So may I request Professor Pandey, Rakesh Pandey ji to stop the class here only.
So I think he's left the meeting.
Oh, okay, okay. So yeah, I think that there is nothing more in the postmodernity. It is an evolving concept, and let us see that how does it take shape. But these are the fundamental issues which is to be taken care of. Thank you very much.
Thank you, sir.
Thank you, sir.